Okay. Good morning, everyone. Can you hear me okay? The sound in here isn't great. There is an echo a lot of the time, so if anyone has trouble hearing me or any of the witnesses as we go forward, just let us know. There are hearing devices available, but again, it's not going to hurt anyone's feelings if you say you can't hear us, so we'll try to accommodate that, okay? We are here in the matter of the State of Arizona versus Russell Allen Ostrom, case number CR 2023-00525. Before we get started, just a couple of things. Thank you for being here. We know jury service can sometimes be an inconvenience, but we're all glad that you're here today. It's important to the court, it's important to the prosecution and to the defendant, so thank you for that. For this morning, we are going to try and get our jury this morning. We'll probably take a break around 10:15, 10:30, so we can stretch our legs, use the bathroom, get a drink, anything like that. And then hopefully we will have a jury picked by noon. If not, we will take a lunch recess, come back after the lunch hour, which usually goes until 1:30, and go from there, okay? It's not as bad as you might think today. I think that it's going to be educational for everyone, even if you don't ultimately get picked to be on the jury today. It's important that if you have a cell phone, you turn that off. So if you haven't done that already, please go ahead and turn your cell phone off. And while we're doing selection, it's important not to post on social media. I don't think that's going to be a problem, but just I'll remind you not to do that, okay? Again, if you can't hear me, please raise your hand, let me know. The court will note the presence of the defendant, his counsel, Mr. DeBrigida, and attorneys for the state, Mr. Beckwith and Mr. Alcorn. Mr. Beckwith, is the state ready to proceed?
Yes, Your Honor.
Mr. DeBrigida, is the defense ready to proceed?
We are, Your Honor.
Thank you. Okay. Can the jury panel please stand and raise your right hand?
Do you solemnly swear that you will make true answers to all questions propounded to you, touching upon your qualifications to serve as trial jurors, so help you God?
Yes. Thank you, everyone. Please have a seat. Well, ladies and gentlemen, we're now going to begin the jury selection process. I'm going to ask some questions to find out if you have any knowledge about this case or about any of the people that might be involved in the case, to find out if you have any preconceived opinions about the case which you might find difficult to lay aside, and to find out if you've had any personal or family experience that might cause you to identify yourself with one side or the other. A lot of these questions were in the questionnaire. They're not designed to pry unnecessarily into your personal lives. They're going to be substantially shorter and more focused than they used to be because you did fill out that questionnaire, and so we already have some information. If I excuse you as a juror, please leave your number, any notepad or pencil and juror badge on the table as you leave. I think you can.
I'm sorry, Judge.
What? Oh, no, is the table outside the door? Yeah, it's just outside. Okay, so there'll be a table just outside the door. You can leave your materials there, okay? There's a few rules I ask that each of you to follow during this process. There are no right or wrong answers to these questions. Please answer truthfully and not the way you think you're supposed to answer. We're asking these questions to determine your true beliefs on certain aspects of the case. Please do not hesitate to tell us your honest views on the matters we discuss. It ensures that we get a fair and impartial jury. And number two, please speak loudly and clearly. Again, the sound in this room isn't great. You'll see two lighted, they look like little discs in front of you, like the things you get at a restaurant. Those are actually microphones, and so hopefully they will be able to pick everyone up, okay? Third, when you have a conversation about yes answers you might have, I'll call on you by number. If I neglect to do that, please remind me and state your number for the record. That's so we have a clear record of who says what during these proceedings. Finally, if at any time there is a question that touches on things that are personal or private, or if for any reason you have some confidentiality to your answer, please let me know. We can discuss the matter in private. I'll let you know private isn't really private. It's just not as public. It'll still have me, the attorneys, the clerk, and the bailiff, but we would excuse the rest of the jury panel. So if there's something you haven't, I guess, answer to one of the questions, but you don't want to talk about it in front of the whole group, that is fine. Just let me know, okay? All right. Before we go any further, I want to introduce my staff. Our bailiff is Kaylin Trimble. He assists us with getting into the courtroom and helps with many other tasks. He may leave from time to time during the trial to perform some of those duties, but he is a great resource if you have questions. Our deputy court clerk is Michelle Ridenour. She's seated to my left. Among other things, she keeps the official record of the proceedings, handles the exhibits, and swears in the witnesses and jurors. I am Deanna Cannon. I am a full-time judge pro tem with the Gila County Superior Court. Do any of you know me or members of my staff? Okay, there's, bless you. So no responses. I'll now introduce the person seated at the table. State is represented by Mr. Beckwith and Mr. Alcorn. Mr. Beckwith, will you please introduce the folks at your table?
Yes, it's myself, Deputy County Attorney Tanner Beckwith, Deputy County Attorney Ryan Elkhorn. We have Payson Police Officer Detective Eric Dunstan, and we also have our Legal Secretary Candace, and a member from Victim Services, Brent Herring.
All right, thank you. Does anyone know Mr. Beckwith, Mr. Alcorn, Detective Dunstan, or any of the staff? No? Okay. So the panel has indicated no. The defendant in this case is Russell Ostrom. He's represented by Mr. DeBrigida. Mr. DeBrigida, will you introduce yourself and your client?
My name is Ron DeBrigida. I'm a solo practitioner. My office is in the Valley, but I mostly practice here in Gila County and also in Maricopa County. My client is Russell Ostrom. He lives here in the Payson area.
Okay, thank you. Does anyone know Mr. Ostrom or Mr. DeBrigida?
No.
Okay. All right. Do any of you on the panel know each other?
No.
All right. I see someone nodding. Number 3. Okay, number 3. Who do you know?
Number 21.
How do you know number 21?
We are both local moms, so we run in the same circle.
Okay. All right. If you and number 21 were both to be picked for this jury, would that cause any difficulty on your part? Would you, if number 21 disagreed with you, would you have any problem voicing your own opinion? No. All right, number 21, same thing for you. So if you're both picked for the jury and you two disagree, you're not going to have any problem voicing your own opinion just because you know number 3 from your mom groups? No? Okay, thank you. Anyone else know anyone else on the panel? No? Okay, no. All right. So, ladies and gentlemen, I know jury service can be an inconvenience to you. I'm sure that you have matters of importance in your life that jury service interferes with. I also hope you understand how important it is to our community that persons such as yourselves are willing to serve on a jury. Our system works because you are willing to come to court, perform jury service, and decide cases like this one. Our Supreme Court has noted, other than voting, serving on a jury is the most substantial opportunity most citizens have to participate in the democratic process. The questionnaire kind of touched on the trial schedule, but let me repeat the schedule of trial. This case is expected to last up to 3 days, so we should be done by Friday. Daily schedule will be from 9:30 to, we try to get done by 5, but sometimes we stay a little later, to 5:30. The law provides that a juror can be excused only if his or her absence from work would substantially and materially affect the public interest or welfare in an adverse manner, or if service as a juror would impose an undue or extreme physical or financial hardship on you or someone under your care. Is there anything about the anticipated length or daily schedule of trial that presents a problem whether it be personal, business, or health-related, that is significant enough that you feel you need to ask to be excused from service on the jury? Anything about the schedule that poses a problem to the folks here? No? Okay. No negative answers. Okay. So we're now going to go through juror number 1 in the back there. I see that you know Sergeant Hansen and that your sons played baseball together. You have a brother-in-law who's an officer. First of all, is there anything about you knowing Sergeant Hansen that would cause you to consider his testimony to be more truthful than any other testimony that you would hear today? No?
Just acquaintances through baseball.
Okay. And then having a brother-in-law that's an officer in Mesa, anything about that that would make you tend to favor law enforcement over any other witness?
No,
So you believe you can be fair and impartial despite that relationship?
absolutely.
Okay, thank you. Excuse me one second. All right. So first of all, everyone is a resident of Gila County, correct? Okay. You'd be surprised sometimes folks aren't residents, but they still get called to jury duty. So everyone is a resident of Gila County. All right. All right. Number 2. You also have families in law enforcement. Is there anything about that relationship that would cause you to favor law enforcement over anyone else?
It might.
Okay, let's focus on that a little bit. What do you mean that it might?
I have a tendency to have a high respect and a little high control and the police.
And do you believe that respect would cause you to possibly treat testimony from a law enforcement officer with more weight than from any other witness?
It might, yes.
Thank you for being honest. You know, let me ask the whole panel, because a lot of you have folks that are in law enforcement or just may have an opinion about law enforcement. Is there anyone else who would tend to find a law enforcement officer more credible just because they are a law enforcement officer? Number 4, can you please expound on that? Can you please expound on that a little bit?
Well, there's 3 of my family that have been involved in law enforcement, and I regard the law, and I lean towards everyone should obey the law, and I feel very strongly about that, and it probably would.
Okay. So even if I were to instruct the jury that you're to give law enforcement testimony no greater weight than any other testimony, that might be an issue for you because of your family that's in law enforcement? Or do you think you'd be able to follow the court's instruction in that regard? Okay, thank you. Thank you for being honest. All right, I saw some other hands. Can you hold up your numbers, please? And the number, can you hold up 17?
I'm just going to probably favor the police officer.
Okay. And why is that?
Well, I have family members, and I just think with the environment that I'm going to lean towards favoring them.
Okay. So even if the court were to instruct you, you're to give law enforcement no greater weight than any other testimony, you might have trouble with that instruction?
I think I would.
thank you. Anyone else? Any other hands? Okay, thank you, everyone. Has anyone on the panel ever been called to testify as a witness in a criminal case? No. Any other kind of case? No one served as a witness? All right, number 13? 14, sorry. Tell me about your experience, please.
It was just a credit card scam. I worked at a place that someone used a stolen credit card from, so I testified that they did.
So you were kind of a fact witness?
Yeah.
Okay. Was there anything about that experience that leads you to have a bad impression of the jury process? Okay. Now, has anyone else ever had a family member or friend who was arrested for a crime or had been a criminal defendant in any way? Okay. Let's start number 16. Can you tell me about that, or is that something you want to speak privately about?
No, my sister was arrested and incarcerated for child pornography.
Was there anything about that experience that might lead you to have an opinion one way or the other about the criminal justice system?
No, previous law enforcement officers.
Okay. Let me follow up on that a little bit. In fact, you are married to someone who is also in law enforcement, correct? Does the fact that you used to be in law enforcement or former law enforcement and are married to a law enforcement officer, does that make you lean towards the testimony of law enforcement in any way?
I would have to say, I would assume if somebody's been arrested, the officer may have the probable cause to make the arrest, but I would still, based on the testimony of the case, let's lay it out, see the facts are present.
Okay. So you would follow the court's instruction that you have to treat law enforcement the same way as you would treat any other witness. You'd be able to follow that instruction? Okay. And then you also, though, know that the law is that the defendant is innocent until proven guilty, and do you believe at that? Okay. All right, I think it was number 21. All right. Can you let me know about your experience with or family members' experience?
My brother was convicted of a felony and served like 6 months or something.
Okay. Now, is there anything about that experience that led you to have issue with law enforcement or with the criminal justice system? Anyone else? Number 4?
My oldest son has been in and out of prison most of his life. He's estranged to us. I just wonder if one about that I would not put. I need to put it off.
Okay, thank you. Has anyone ever had a family member who was a victim of a crime, or have you been a victim of a crime yourself? Number 8, okay, number 18? Yeah,
My daughter was home invaded a few years back. She was in California.
And was there anything about that experience that led you to either have an issue with law enforcement that investigated that crime or with the criminal justice system?
No, she testified against, they found the guy and he went to prison.
And despite that experience, do you believe you could still be fair and impartial in this case, which alleges property crimes?
Yes.
Okay. Anyone else? 16, please.
Late parents and a dog and burglary.
Okay. So nothing about the crime that would lead you to have a negative opinion about how they were treated or the criminal justice system, anything like that? No? Okay. And you could be fair and impartial in a case that alleges a property crime? Yes? Okay. Anyone else? Number 19.
My parents have had their homes broken into multiple times, and both of them have had their identity stolen.
Has anything about that experience led you to have an issue with how they were treated by law enforcement or with how the system treated them?
Not at all.
Would you have any issue being fair and impartial in a matter that alleges a property crime? You believe you could be fair and impartial? Okay. Anyone else? No? All right. Now, you all received a statement of the case, which alleges that on or between November 15th and November 18th of 2023, the defendant, without lawful authority, retained a vehicle despite several demands for the property to be returned and removed the vehicle from its known location without the owner's permission. Defendants pled not guilty. Is there anything about the nature of the case that would make it difficult for you to serve as a fair and impartial juror? I don't see any yeses. All right. Is there anyone other than number 1 who knows any of the people listed? Any of the potential witnesses? Okay, number 3. Who do you know?
My husband played softball with Officer Hanson, and I know his wife through, again, like local law circles, but we're very loosely acquainted.
Is there anything about that acquaintanceship that would make you tend to favor Sergeant Hanson's testimony over other witnesses? You believe you could be fair and impartial? All right, great. Anyone else know any of the folks that were listed? If you want me to, does anyone need to be reminded? You all answered your questionnaires, so, okay. Is there anyone here that has heard anything about this case? Read in the paper, on Facebook, anything like that? No? All right. Have anyone here ever had a close family member, or you yourself ever studied law, practiced law? No family members. Okay, number 14, right? Okay,
My sister's a corporate lawyer.
okay. Anything about that relationship that would cause you to be not fair or impartial in this case? Okay. Anyone else? Know anyone with any legal training? No? All right. Has anyone here, either themselves or had a family member, practice medicine or work in the healthcare field? No? All right. Oh, number 2.
My sister is a nurse, and my niece is a nurse.
Now, this isn't a case that's going to have much, if any, kind of medical testimony, but is there anything about those relationships that would cause you to be fair, unfair or impartial in this case? All right, thank you. Anyone else?
My wife was a medical assistant.
Okay, number 22, again, same thing for you. Anything about that relationship that would cause you to be fair and impartial in a matter such as this? Okay, and number 1.
Our cousin's a pharmacist,
Okay.
and my daughter was a CNA.
Okay. And again, that question's a lot more relevant if we were to have like a blood draw in this case, or if there was some kind of medical issue. I don't believe there is, but in case there is, we need to ask anything about those relationships that would cause you to be less fair or impartial in this case. No. Okay. All right. I know most folks reside in the Payson area. Is there anyone who resides outside of Payson? Number 16. Okay. Is there anything about living in Young that is going to make it difficult to get here if you're selected for the jury? No? Okay. Anyone else? Number 11. Okay. Anything about living in Star Valley that would make it difficult for you to get here if you were selected?
Not as long as you guys put money on the card.
Okay.
Yes.
Okay. Anyone, number 5?
Star Valley.
Same thing, any issue getting here from Star Valley? Okay, number 20?
For the winter, my husband and I are living in Apache Junction right now.
Okay,
But our main address is Payson.
so you're a resident of Payson, but right now you are living in Apache Junction for
Right,
the cooler
winter,
months.
For the winter.
Anything about getting here from Apache Junction that would cause a hardship or be difficult for you?
No.
Okay. Anyone else? Number 13.
Yeah, I live in Young.
Okay. Anything
You
about,
said it might not get over till 5, and it's another hour and a half drive home.
right,
That's kind of, and 28 miles of dirt road.
okay,
I've totaled one truck falling asleep at the wheel. That, I thought it'd be over at like 2:30 or 3.
okay, so the fact that it might go into the early evening might be a hardship for you because of where you live?
Driving back in the dark, yeah.
Okay.
I'm sorry, Judge, what number is that?
13?
No, is it 13? Are you number 13, sir?
Pardon?
Are you number 13?
13.
Sorry, Judge.
No worries. All right, anyone else live outside of Payson city limits? Number 10.
I live in Washington Park,
Okay, and how far is that from here?
15 miles.
Okay, any issue getting to court or getting home? Okay. Anyone else? No? All right. So I'm kind of going to go down the line and ask you some questions about they're not really personal things, but I'd like to know, 1, are you married? 2, if you have minor children. 3, what is your profession? Or if you're retired, what was it before? So we'll start with number 1. Are you married?
Married.
Okay, and any minor children?
No.
What was your occupation, or what is your occupation?
Education.
Okay, and what about your spouse? What is your spouse's occupation? Okay. All right, number 2.
I'm married, I have 2 children. My son is a fireman, and my daughter works in the regular office. My husband is a chaplain for the Highway Patrol, as well as a minister, and prior to that, he was a policeman.
Okay.
I taught school, and
thank you. Number 3.
I'm married and have a 9-year-old and a 7-year-old. I'm currently a church administrator, and I was formerly a teacher, and I homeschool my children now. My husband's a pastor.
You said you homeschool your children?
Yes.
Is there anything that is going to interfere with that if you were selected for the jury today?
No, they can take 3 days off.
Okay, all right, fair enough.
They're great with it, yeah.
Okay. And you said they were 9 and 7?
Yes.
Any issues with childcare or anything like that?
No.
Okay. All right. Number 4.
Married. My wife was a 911 dispatcher in Riverside County, California. My youngest son is a Salvador police officer. None of my kids are athletic kids.
Okay. So they're all grown?
They're all going.
Okay. Number 5.
I'm widowed and I worked for Mason Public Schools for years and retired.
Okay. Number 6.
I'm married, I'm retired, I was commercial property manager, and my husband worked for a cable TV company.
Okay. Number 7.
Married, all the kids are older, so they all went out without, we have grandkids,
Okay.
like 5 or 6. And what was the question? Well, occupation.
Yes.
Oh, I work at a bank, and I do recovery from litigation officers, we sue businesses, like business loans.
Okay.
It's all civil business related.
All right. And what about your spouse?
She's Aaron Bauer.
Okay.
That's the one.
Number 8.
Oh, they got consent.
Sorry? Oh, 8 got sent home. You're right. 9.
I'm a widow. I work part-time. I do self-finance. My husband was a ceramic tile and stone contractor in California.
Okay. Thank you. Number 10.
I'm married, building inspector, and no.
Okay. And is your spouse employed?
Pardon?
Is your spouse employed?
She's retired also.
Retired. All right. Number 11.
Okay, I'll be the first one to say divorce. My kids are all grown. I went to early retirement. I was in hospitality as a daughter for many, many years.
Okay. Number 12.
I'm married, live here, I live here in Payson, and my wife was a controller for a family business in Minnesota. And that's about it.
Okay. What about you? You said you're retired?
Yes,
And what did you do before? What did you do before you retired?
I am a mechanical engineer.
Okay, thank you. Number 13.
Divorced, retired data center engineer, and I got 1 grandson, or 2 grandsons, 1 son, and stepson,
Okay,
and I live in,
all right, thank you. Number 14.
Married, no kids, retired from the auto industry. My wife still works, and she works for a computer software company.
All right, thank you. Number 15.
15 was excused.
15 was excused. 16.
Married, 3 adult children. Young husband is chief deputy for the county sheriff's office. And Most of my career has been in public service, 14 years law enforcement, 8 years with the radar company, data analyst, and last position was the assistant fire chief for the Young Fire Department.
Okay,
Currently not.
thank you. Number 17.
I'm married, one adult child, trying to retire. We did construction, had our own company and built homes down in the valley. I do own a basic campground in our resort, but my son is running it now, so I'm trying to back up and retire.
Okay. Number 18.
Married, 2 children, both adults. Wife and I are both retired. I worked for the defense company Raytheon in Tucson. I was in contract.
Okay. And did your spouse have a job before retirement?
Pardon me?
Did your spouse have a job before retirement?
Yeah, she actually worked for Raytheon as well.
Okay. Number 19.
Separated, I have a 3-year-old, and I work at the casino as a slot technician.
Is there anything about having a minor child that would make it difficult for you to serve on the jury? No issues with childcare, anything like that? No? Okay. Number 20.
Retired, no minor children at home. My husband and I were ranch managers for 27 years in Gila County.
Okay. Thank you. $21.
I'm married. I have 3 children at home, ages 7, 11, and 13. And my husband and I are both educators.
Okay. Is there anything about serving on the jury that would make it difficult for the 3 minor children that you have? No. Last but not least.
Okay, I'm married to a retired medical assistant from Merrill Neurosurgical.
Okay.
I'm a retired cabinet maker, installation.
All right. Now, has anyone served on a jury before? Okay. Oh, wow. Okay. Let's start in the back, number 2. Was it a criminal or civil trial? What was the verdict? And were you the foreperson? Yes.
I was on it many years ago. It was a murder.
Okay, it was a criminal trial, and I believe your questioner said it was a guilty verdict. Is that right? Okay, and were you the foreperson? Were you the foreperson? Okay. Who else had their number up? Number 5.
It was a DUI case, and he was found guilty, and I was not court.
Okay. Number 6.
I've served several times. One was a murder case, one was excessive use of force by a police officer, one was rape, one, some of them were in California.
Okay. And did you serve as a foreperson on any of those juries? Okay, and do you remember, it sounds like you had quite a few, but do you remember the verdict? I think murder was guilty, I think you said.
The excessive use of force, we found for, I believe that was a civil case.
Okay.
We found in favor of the police officer.
Okay.
The rape case, the guy was guilty.
Okay.
And then, I forgot.
That's okay.
30 years.
Right. Okay. Who else had their number up? Number 7.
One was a DUI case in the valley, guilty, was not reported, and the other one was armed robbery, but he kind of typically day one trial. So they were actually against the
Okay, so you were selected for the jury, but in between hearing evidence, there was a plea.
Yeah, I guess he was representing himself, and they just acted for jury service, and finally, I guess he didn't have a case, he did represent himself, so
Okay,
he just let us go, and said, "Here's the details."
okay. And on the DUI, were you the foreperson? No? All right, who else had their numbers up? Number 11.
It was a criminal case, assault with a deadly weapon. We found him guilty, gave him maximum sentence. I was not the foreperson.
Okay. Is that in Arizona?
It was in Amarillo, Texas.
Okay. $18.
It was a DUI case, he found guilty, and it was not the foreperson.
Okay. Number 20.
Criminal drug case, not guilty, and I was not the floor person.
All right, anyone else have any jury service? No? All right. So as the judge, I'll be instructing you on the law to apply to your deliberations. Is there anyone who has issue following the court's instructions? Do you have strong opinions about what the law should be as opposed to what it is? Is there anyone that would have difficulty following the court's instructions as they relate to the law? No? No affirmative answers. I'll instruct you that you must render a verdict based solely on the evidence that's presented at trial. Is anyone not willing to follow this instruction? No? Okay. Now, we've touched upon this a little bit with the topics, but is there anyone, if selected as a juror, that is not willing to be fair or impartial to both the defendant and the state? And everyone willing to be fair and impartial to both sides?
Yes.
Yes. Anyone not willing to be fair and impartial to both sides? No. Okay. We touched on this a little bit also. The law requires the state to prove the defendant guilty beyond a reasonable doubt. I'll be giving instructions on what that is. The defendant is presumed by law to be innocent. This means the defendant is not required to prove innocence or to present any evidence. Does anyone disagree with these principles of law? Does anyone have an issue with the defendant is innocent until proven guilty? The defendant does not have to present evidence or prove innocence. Anyone have an issue with that? No? Okay. Now, just in general, is there anything we've touched upon that you want the parties to know one way or the other? Do you think maybe the prosecution wouldn't want me on this jury, or maybe the defense wouldn't want me on this jury? Is there anything we haven't touched that is important for either side to know about serving on the jury? No? Okay. Those are the questions I have. We're going to take a short break so we can get a drink, stretch a little bit. The attorneys might have some additional questions for you, but I'm going to meet with them while you take your break, and we will come back in. Let's come back at 10:30, and we'll go from there, okay? Thanks, everyone. seated. The record will reflect the absence of the jury, the presence of the state, the defendant, and defense counsel. Based on what we heard so far, I'm inclined to strike number 2 for cause. This person indicated that he would have difficulty, that they would give law enforcement testimony maybe more weight than other testimony. Any objection to the court striking number 2 for cause?
Yes, Judge, and in fact, I would have an objection to striking any jurors for cause at this point. We haven't had an opportunity, the state hasn't had an opportunity to voir dire any of them or follow up on any of the court's questions to clarify their attitudes or opinions. I would object to striking any jurors at this point.
Okay, Mr. DeBrigida?
I would request that juror be struck for the reasons the juror gave and Your Honor's explanation.
Okay. Well, to let the parties know, I am inclined to strike number 2, but Mr. Alcorn, if you really want to question number 2, I'll let you, but at this point, I think it would be difficult to rehabilitate that testimony.
I understand that, Judge. I just want the opportunity to clarify on the court's questions.
Okay. And then that would be also as it relates to 4?
Yes, Judge.
Okay. I am inclined to strike 4 as well, so that he's leaned heavily towards law enforcement, but I will give the state a chance to question, but right now my inclination is to strike 4. Mr. DeBrigida, do you have a position on that?
I agree with the court.
Okay. And then number 13, I'm inclined to strike for hardship. It sounds like he has some difficulty driving at night, lives in Young, and it would be hard for him to get home. Any objection to striking 13 for hardship?
For hardship, no objection, Judge.
Any objection, Mr. DeBrigida?
No, Your Honor.
So we'll strike 13. And again, I am going to let the state and the defense question witnesses. Any issue, I'm kind of concerned about number 16 and her close relationship to law enforcement, but I will give the state a chance to question her further. Gila County Sheriff's Office isn't involved in this case. I do not believe all the officers are from Payson PD. Correct?
Correct.
Yes.
All right. But I am kind of leaning towards that one for cause. Any others that we should be paying attention to when the jury comes back?
If I'm hearing the court right, we're going to have those 4 jurors come back in separately?
Not 13. 13 we're going to...
I meant the 4 remaining. You indicated, and I've identified as well, the 3 that indicated that they would give greater weight to a law enforcement officer.
Yeah.
And then you're also concerned about juror number 16, on list number 16. Are those going to be spoken to individually, or are we going to bring them individually by themselves, or are they just as part of the panel?
I think we'll just bring the panel back in, but certainly if you want to question them individually, I'll let you.
I just wasn't sure what the plan was.
I think we'll just bring them back in. 13 we'll let go for hardship. And then those other 3 identified, right now I'm leaning strongly towards striking them for cause, but I will give the state that opportunity to question them. Any others we should be keeping an eye on? No? Okay. All right, let's take our recess so everyone can stretch, run to the bathroom, get a drink, whatever you need to do, okay? All right. All right, we are back on the record in CR 2023-00525. The record will reflect the presence of the state, the defense, and the panel. Oh, sorry, I got to sit right on the microphone. Thank you. So that's exactly what you're supposed to do. Thank you. Okay. All right, so the court's finished asking questions. Mr. Beckwith or Mr. Alcorn, do you have any additional questions for the panel?
I do, Judge.
Go ahead, please.
Thank you. Morning, folks. My name is Ryan Alcorn. You won't hear from me a whole lot during this trial. Mr. Beckwith is going to be largely in the driver's seat, but he's never done voir dire before, so I'm here to conduct some voir dire. Voir dire is a term. It's a French term. It's just the process that we're going through here. Just asking you questions and finding out if you're the right jury to sit on this case or not, which is what Mr. DeBrigida and I are really looking for. I start out my voir dire with probably the hardest question that I could ask. And I do this on purpose for a few reasons, and I'll get into those reasons in a little bit. But the first and most difficult question that I have for all of you is there anybody who, as you sit here today on the panel, really just doesn't want to be here? Okay, raise the placards. It's okay. I appreciate honest answers, so please raise them high. Numbers. I need numbers, please. Okay. So for the record, I'm sorry, keep those up so I can make a record, please. So that for the record, that's number 4 and number 5, number 10 and number 12. And in the bottom row, it's 17, 18, 19, and 22. I appreciate that answer. I don't actually always, you'd be surprised. Sometimes I get, like you folks, I get a lot of people that are like, oh yeah, I just want to be out of here. And then sometimes I get a panel that, nobody raises their placards, and I don't know if they're lying to me or what the case may be, but I appreciate your answers. I'm going to ask a lot of group questions. I'm going to ask some of you individual questions. I don't anticipate this to happen, but it could, and I kind of want to get out in front of it and explain it up front. If I, or if Mr. Beckwith, don't think that you're a good fit for this jury panel, we have to make an argument to Judge Cannon. And in order to do that, it used to be, when I first started practicing, I think before Mr. Beckwith started practicing, and Mr. DeBrigida remembers this, we used to have what were called peremptory strikes. And so we would argue over whether you all were right for the jury or not. And then Mr. DeBrigida and I got to excuse anybody that we didn't like, as long as we were not being prejudiced, as long as we were excusing them for race-neutral reasons. As of about, a couple of years or so ago, we no longer have peremptory strikes. And so what that means is, in order for me to make a record for Judge Cannon to consider whether or not you're right for this jury, sometimes you do things, you might make facial expressions, or if I notice someone falling asleep, that doesn't pick up on the recording. And so I have to make a record of it, typically by asking you. And it's weird in our society because I have to sort of confront you with this behavior. And it's not because I don't like you. It's just because I have to make an audible record because the record is being recorded. And so in order for Judge Cannon to agree with my arguments or disagree with my arguments, I just have to say those things out loud. So I apologize for that in advance. So I'm going to ask some group questions that are kind of designed to figure out what your preconceived notions about the case might be. And I want to start with something that Judge Cannon asked, and I think several of you had some answers to, which is sort of the role of law enforcement in this trial. Is there anybody who, by a show of placards, if I were to call Detective Dunstan and he were to testify that the traffic light was green, let's suppose that that's a fact at issue in the case, and then suppose I called another witness who wasn't sure, or maybe another witness who testified that the light was red, maybe Mr. DeBrigida called another witness who testified similarly. Is there anyone who doesn't understand? You must consider, you have, see, how do I put this to, I always try to avoid double negatives. Is there anybody who doesn't understand that you have to treat the witness's testimony all the same to a certain extent? Everyone understand that? Okay, everyone's, if the record could reflect, everyone's nodding their heads. Now, does everyone understand that you can judge the witness's testimony by their demeanor, or what they say, or how they testify? Does everyone understand that?
Yes.
Okay, yes. So, if Detective Dunstan gets on the stand, does everybody understand that he might do a horrible job, and you can weigh his testimony as not credible? He might testify, I don't know, I don't remember, you know, a huge variety of things that might make you decide, well, you know, gee, he's a law enforcement officer, but I don't really find his testimony credible. Does everybody understand that? Okay. So I want to get into a couple of you. Number two, I think you had indicated that you would give more weight to law enforcement officers' testimony. Is that because, so for example, in my example, Detective Dunstan testifies, and let's suppose he testifies to something that's important to the case. Are you going to believe Detective Dunstan's testimony merely because he's a law enforcement officer? Okay. Do you feel that he receives training and experience that makes him a better witness? Do you believe that that's the case? Okay. If Detective Dunstan gets on the stand and testifies to something that he feels is really important to the case, and then let's suppose that Mr. DeBrigida calls a witness, and by the way, he doesn't have to, but let's suppose that he does, and that testimony completely let's say, again, Detective Dunstan testifies the light was green, and Mr. DeBrigida's witness testifies the light was red. Are you going to be able, number two in particular, are you going to be able to evaluate the testimony of those witnesses based solely on how what they say on the witness stand and how they act on the witness stand? Okay. Are you going to believe Detective Dunstan's testimony merely because he's a law enforcement officer?
Not necessarily.
Okay, so if he gets up there and he really donks it up, you know, are you going to be able, I guess what I'm trying to get at is, you know, I have a responsibility to, or it's my duty to present the facts and try to convince you beyond a reasonable doubt of the defendant's guilt. And so if Detective Dunstan gets up there and really messes it up, are you going to be able to evaluate the testimony and potentially find Mr. Ostrom not guilty?
Yes.
Okay. Number four, I apologize, number two, for really just drilling in. Number four, similar set of questions. I think you have a similar attitude. Is that correct? You agree with everything that she has said so far? Okay. And so just to be clear, would you believe Detective Dunstan's testimony merely because he's a law enforcement officer?
Not necessarily. I know that they're trained more to notice things and try to remember things.
Okay. Let me ask a question this way then. Suppose that Detective Dunstan, I'll get to you in a second, number 14, I see you. Oh, I thought you were itching to talk to me. Suppose that Detective Dunstan doesn't testify, because again, we're talking about the testimony he gives in court. Suppose that Detective Dunstan gets up here and he doesn't testify that he has any training or experience in observing anything any better than anybody else. And so that's not a fact in front of you. Would you be able to evaluate the witness's testimony the same?
Yes, the same as.
Same as any other witness?
Yes.
Okay. Number 16, I know you have previous law enforcement experience. So I think you understand exactly what I'm saying. Is that right? Okay. Is that a yes? I apologize for picking on you. Unfortunately, you're the first one to do it. And don't go on the record very well. That was true even when we had a court reporter who was typing everything down, and that's especially true for audio. So I apologize for making you the example, but if we could get a yes or a no, I would appreciate that. That was a yes, number 16? Okay. And so, have you ever had to testify? Okay. I want to put you on the spot, but have you always done a good job? Okay. And so, I guess I'll ask you the same question. Would you be able to evaluate the testimony of the witnesses, not based on what their profession is, but based on the way they testify, the things that they say, etc.?
Yes.
Okay. You mentioned something about probable cause, number 16, correct?
Yes.
Okay, and so you feel that if an officer made an arrest, you would believe he or she would at least have probable cause?
Yes, and they're going to take the civil rights away from somebody else.
Okay. Number 16, you understand that standard and what we're here for beyond a reasonable doubt, those are different, right? Okay. Is there anybody, I'll take a placard, anybody who wants to volunteer who can tell me what beyond a reasonable doubt means? Anybody? Yeah, I didn't think so. Beyond a reasonable doubt are some legal words, and taken individually, they have meaning, but it's hard to wrap our brains around what beyond a reasonable doubt is. So the judge is going to instruct you. She's going to give you an instruction that essentially says, it's a little bit longer than, but I'm going to paraphrase it. It says that proof beyond a reasonable doubt is proof that firmly convinces you of the defendant's guilt. Now, does anybody think here, raise your placard if you do, does anybody think proof beyond a reasonable doubt is proof beyond a shadow of a doubt? Okay, I see no placards. Does anybody feel that proof beyond a reasonable doubt is proof beyond all doubt? Okay, I see no placards. Now, related to the burden of proof, if I sat down and Mr. Beckwith didn't stand up and didn't address you, and we presented no evidence, does everybody understand that the defendant is not guilty at that point? Does everybody understand that? Anybody not understand that or confused by that? And so if we presented no evidence and you were asked to decide the case, your decision must be not guilty. Does everyone understand that? Okay. If the record can indicate, the jurors are nodding their heads. Now, likewise, if Mr. Beckwith goes through this trial, presents testimony as he intends to do, and that testimony does in fact firmly convince you of the defendant's guilt, does everybody understand they will be instructed that they must find the defendant guilty? Does everyone understand that? Yes. Great. I think that answer was on the record. Number 17, I think you also had you had indicated that you would believe the testimony of a law enforcement officer over other witnesses. Is that right? Kind of? You look a little confused.
Well,
have I talked you out of it?
Well, I have a lot of respect for them, and I'm afraid I would lean that direction.
Okay.
But I would try, be open-minded.
Okay, so you feel that you might in fact believe Detective Dunstan's testimony simply because he's a law enforcement officer? Maybe? Okay. Thank you for that answer. I appreciate it. No, that's perfectly okay. A maybe, a yes, or a no are all perfectly valid answers. So thank you. Now, a significant number of you have some prior jury experience. So I kind of want to talk about a little bit about evidence. Does anybody here on the panel think that Mr. Beckwith or I or any of the witnesses are going to get up and sort of present the level of evidence that you see on television? Does anybody think that? Does anybody think that it works the way that it does in CSI? Is everyone familiar with, the CSI episode? They get like a 480p video of a, gas station parking lot or whatever, and then they zoom and enhance and they can figure out like the license plate number. Does everybody understand that that's not really how it works?
Yes.
The way that he indicated?
Yes.
Okay. Number 2, talking about that murder trial. How long ago was that?
It was a long time ago. I was probably 21 years old.
Okay.
It was very different.
So like maybe 10, 15 years ago?
Oh, yeah.
Was that here in Arizona?
It was in Arizona.
Okay.
And the trial consisted of 2 people that wanted to kill the grandfather. And in the process, they killed the housekeeper.
Okay.
And so they had to decide whether or not she was involved at all. If she was involved at all, she was still part of it.
Okay. All right. Interesting. So kind of like an accomplice liability sort of situation.
What was good for me after it was over was they had a retrial and came up with the same thing as the first trial.
Okay.
So that helped me as a young person.
Okay. Interesting. What kinds of evidence, if you don't mind sharing, did they present at that trial?
Oh my, that's a long time ago. They brought in people that had been in the beauty parlor, that had heard them making the connection between let's get these people to go in and kill this grandfather so we can get the money. And so there were several people that were there that heard the conversation. And so they had hired young people to come in, or when they did come in, they killed the wrong person.
Okay.
So, yeah.
Interesting.
There's a lot of information.
Do you recall if the state presented any evidence to you of like fingerprints?
I don't remember.
Okay. And similar question, do you recall if anyone presented any evidence of like DNA?
I don't know that they did that.
Do you know if any like scientists or kind of like chemical experts came in and testified? Okay. So, by a show of placards, I'm gonna ask a trick question. So don't feel bad. There's gonna be an aha moment here. Show of placards. Who feels that? I'm gonna ask them together. Fingerprints or DNA or both are direct evidence of a crime. Okay. So that is number 5 and 6, number 2, number 9, 10, 11, and 13, number 14 and 18, number 17. Number 7, are you on the fence? Okay. Okay, so I'm gonna spill the beans. Fingerprints or DNA are not direct evidence of a crime. Here's why. You'll receive an instruction that direct evidence is the testimony of a witness who heard, saw, or otherwise experienced an event as they described it. That's all direct evidence is. Circumstantial evidence, here comes a really helpful legal definition. Circumstantial evidence is evidence of a fact from which you can infer another fact. So I'll give you an example. My child is 7. My child has a lot of interests that I don't have, and so I try to find things that we can do together with mutual interests. One of those mutual interests is baking. My child likes to bake, and more specifically, she likes to watch me bake. And so we might bake cookies together. However, my child, because she's 7, has a problem with impulse control, and so she's not allowed to have a lot of sweets. So the cookies might go into a cookie jar, and then on Wednesday, which is a day which she's not allowed to have sweets, I notice that the cookie jar is empty, right? Now, I haven't seen or heard that my child has eaten the cookies. My wife didn't either. This happened at some point when I wasn't looking. However, I notice, because my child can't use a napkin and just loves to wipe, everything on her dress or her shirt, that she has, chocolatey fingerprints all over her shirt, and maybe they're on her mouth, and the cookie jar is empty. Everybody understand that those types of evidence, that's circumstantial evidence that she has eaten the cookies. Does everyone agree that I ought to be firmly convinced that my child ate the cookies? Okay. So I think you can kind of see where I'm going. Does everybody understand that if I touch a surface and I leave a fingerprint, That is no more than circumstantial evidence that I have been at a place. Does everybody understand that? Likewise, if I leave DNA behind at a crime scene, for example, suppose my blood is in an apartment for some reason, right? That's circumstantial evidence that I was at the apartment. Does everybody understand that? Now, you'll receive an instruction that the law does not treat direct or circumstantial evidence any differently. They are to be treated the same, and you all are free to give every piece of evidence whatever weight that you feel that it deserves. Does everybody understand that? Okay. Going back to you, number 2, I'm sorry. It sounds like there were a lot of witnesses that were presented at that murder trial. Are you expecting the state in this trial to present as many witnesses as were in that trial? Okay. If the state presented only one witness, let's say it was just one person that testified, but that person testified really well, is it possible in your mind that that could be proof beyond a reasonable doubt? Or is there no way? Must I present more than one witness in your mind, number 2?
I usually think there should be 2.
Okay. Does anybody feel similarly, and again, honest answers, I don't really care what the answer is, it helps me think about whether you're right for this jury or not. Does anybody agree with number 2? There should be at least 2 witnesses. Or sorry, yeah, I suppose more than one. Okay. Number 3, number 5, 10, 13, 12, 17, 19, 20, 21, and 22. Thank you. I'm going to move on to number 6. It's your turn to get picked on. You have a lot of experience with jury trials. In the sense that you've sat through a lot of them. Okay. And you've probably seen a number of attorneys do exactly what I'm doing right now. Is that a yes?
Yes.
Similar question as I asked in number 2. I don't know what kind of evidence was presented in those cases, but are you expecting the same level of evidence as you have seen in the past, or does it matter to you?
I don't expect it. When I was sitting on the one with the police officer who was expressing his support, we actually had someone come in and explain how a police officer, the police officer doesn't raise the level of what he does. They just go by, like, here's the bad guy doing what he's doing, and they respond to that. And we try that. And it was really interesting.
So kind of an expert.
Yeah, it was an expert.
Okay.
In the murder case, it was mostly, there weren't a lot of witnesses. There were more character witnesses. It was a retrial of someone who had been, had let off with self-defense.
Okay.
And then it was retrial.
Interesting. Okay. If the state doesn't present an expert witness, I don't call a chemical expert, I don't call a behavioral scientist, I don't call a fingerprint expert or a DNA expert. In your mind, are you going to be able to be firmly convinced if I don't present that evidence?
I believe you will present what witnesses will benefit your case.
Okay.
So if you needed an expert for your case, you would have.
Okay.
But if you only have one witness, okay.
Okay. You'll receive an instruction. It's actually, I think, one of the very first instructions that you receive, that you must decide the case based on the testimony and evidence that you hear. Are you going to be imagining things that I haven't presented, or sort of like filling in the gaps?
No.
Okay. Likewise, Mr. DeBridgen and his client doesn't have to present any evidence. Do you understand that?
Yes.
Okay. And so if he doesn't present any evidence, are you going to hold that against him?
No.
Does everybody agree with that? All right. Number 11, I want to pick on you because you said something that was really interesting. You said you were on a jury in Texas, and you found that guy guilty? And the thing that I found interesting was you said you gave him the maximum punishment under the law. Okay. Now, I don't practice in Texas, but I have it on good authority that in Texas, and number 11, you can confirm or deny, in Texas, the jury decides what the punishment is. Is that right?
That's correct.
Okay. And so they might get some instruction from the judge on, well, here's the least that you can do, and you can't do anything more than this, and then you guys get to decide based on what you hear, sort of what the punishment is. Is that right?
That's correct.
Okay. You're all going to receive an instruction that in Arizona, that's not how that works. It's okay, but you'll receive an instruction that the jury is not to consider the punishment. So in Arizona, a jury doesn't decide, if you find Mr. Ostrom guilty, you don't get to decide how he's punished. That's left up to the judge. Does everybody understand that?
Yes.
Okay. Is there anybody, perhaps you, number 14, who disagrees with that perhaps the jury ought to get to determine the punishment? I see no placards. Number 11, you were, no, I'm sorry, no, it was number 12. I think I have my numbers wrong. Are you number 12? You are number 12. Okay. I think I heard that you said you were some type of engineer. Could you tell me a little bit more about that? Like, what did you do?
I was a design engineer. We manufactured fire detection equipment.
Okay. That doesn't sound like it has anything to do with, like, cars.
No, this is all industrial.
Okay.
Mostly gasoline and oil related.
Gotcha. Along those lines, does anybody on the jury panel have any experience as a mechanic? A mechanic, like a person that would work on a car, outside of like your own normal maintenance. Okay, I see no placards. Does anybody have any experience with their vehicle being stolen? Does anybody on the jury panel, number 14? Do you mind sharing that?
I had a Trans Am stolen, the truck stolen, and a Corvette stolen.
Okay. Was that here in Arizona?
No, it was in California.
Okay, great. Well, I'm not responsible for that. Okay, good.
We got two of the guys.
Number 2.
I had a rental car stolen. I left my keys in the trunk, in the house. Somebody took the keys out of the trunk and took off with the car.
Oh.
And it ended up in Mexico. And they found it, and I didn't know how to pay the car service station.
Gotcha.
Yeah.
Gotcha. How long ago was that?
Maybe 20 years ago.
Okay. Was that here in Arizona?
Yes, it was in Yuma.
It was in Yuma? Okay. Still not responsible for that. Rain check number 14. Rain check. Does anybody have on the panel experience with, has anybody sort of lent their car to another person? That's not like their spouse. Anybody have any experience kind of lending their car out to someone? Let's see a placard, if I may. Okay, a lot of you. I'll say it for the record. It's 1, 2, 3, 7, 13, 19, 20, and I think I said 13. I heard number 14's comment, so I'm including him anyways. Now, of those of you that kind of have that experience or have that experience in your head, have any of you had experience where whoever you lent your car to, they didn't return it, or they didn't return it the way you liked or on time or anything like that? Does anybody have any experience with that? No. Number 4 and number 7. So let's start with you, number 4. Can you share that with me?
Yes, I was living in California. This guy, I hadn't known him very long, but he knew a friend of mine. And one part of my truck moved in somebody. And I just sat like a 3-4 hour man. It was late in the day. I was worried about my truck.
Yeah.
And I'm saying we finally brought it back, and he brought it on, why, bunch of excuses, and
Gotcha. Did you end up like calling the police or anything, or was that kind of the end of that?
no, I didn't find out that I was about to.
Gotcha. All right, thank you, I appreciate that. Number 7?
Yeah, Seth's a middle kid, he's always off and on, party drugs, homeless, not homeless. Yeah, he's in the car for a few hours, 3 days later, in the car back, kind of thing.
Okay.
So, just hiding keys.
Have you ever had to call the police or anything?
I mean, I'm sure yes. We've been together for 13 years.
Gotcha.
We've had patches here and there. It's kind of, we've never gotten arrested over it.
Okay,
I'm sure.
gotcha. You talk a little bit low, Mr. DeBrigida. Were you able to hear that okay? Okay, great. I wasn't having a problem, but I want to make sure, because again, the room's acoustics are not very good. Anybody else? Yeah, number 1.
My nephew borrowed my car one time, just said he's gonna rent it. He was gone for a while.
Okay,
So I was just angry because it's just a respect thing.
sure.
To let me know that, hey, I'm gonna take my friend home, and then I'll be back.
Gotcha. So the mission was different.
Yeah.
Gotcha. Okay. That kind of wraps up the questions that I had, except I want to go back to the very first question that I asked, which was the difficult question. Now, I've obviously talked an awful lot. I don't have a clock. I've talked for approximately 45 minutes now. Fortunately for you folks, this is probably going to be the last time that I address you. Mr. Beckwith is going to handle, I imagine, most of the rest of the trial. So you can probably tell I like the sound of my own voice and I like talking. You might hear from Mr. Beckwith a lot, or you might hear from me, depending on how the trial goes. But having sat through all of my questions and all of the things that I have to talk about, is there anybody here who did not originally raise their placards, but are thinking now, you know what, I just really don't want to be here? I asked that question at the opening and at the end because sometimes it's a little bit difficult to answer that question right up front, but it can become easier as we go through this process to answer that question at the end. So I like to end with that just to make sure I've kind of caught everyone. Judge, I have no further questions.
Right.
Thank you.
Mr. Osborne. Mr. DeBrigida.
Thank you, Your Honor. Good morning again.
Good morning.
So, unlike my colleague, I'm not going to get into a recent history of post-COVID jury trial selection processes. But I do want to pick up on some of the things we've talked about and some of the things that Her Honor talked about in her preliminary questions to you. Let me start with this. How many of you, as you sit here now, think that just because my client Russell is sitting there, he must have done something wrong? Is there anybody that believes that? Good. I'm glad to hear that, because a lot of times I do get answers of people that have just said that they understood that the state's burden is beyond a reasonable doubt and a defendant must be considered innocent until proven guilty. And a lot of times I do get responses that, well, if he's sitting there, he must have done something wrong. Now, that's not to say that potential jurors aren't prejudging him as guilty, but just as human nature, it's got to be in the back of your mind that, well, he must have done something wrong if he's sitting here and it's gotten to this point. As a retired law enforcement officer told us, it's her belief, which I don't disagree with, that somebody shouldn't be arrested or charged unless there's at least probable cause. A lot of what we do in the criminal justice system, and with a jury trial in particular, can be somewhat counterintuitive to what we do as human nature. And let me move on to another topic. Her Honor indicated that, or told you, that my client has an absolute right not to testify. He can't be compelled to testify, and that goes back to the Fifth Amendment that you've all heard about and perhaps seen on TV and all that good stuff. But is there anybody who, notwithstanding that instruction, would hold it against my client or may build into their consideration and evaluation of the evidence whether my client testifies or not? Is there anybody who would have at least wondering, well, what would my client have had to say about this if he doesn't testify? Is there anybody who feels that way? And I see no responses. I know that Mr. Alcorn also talked to you about the burden of proof. The other unique thing about a criminal jury trial is that it's not about money, it's not about who's more right or wrong than the other. It's about, has the state proven its case beyond a reasonable doubt? Now, ultimately, the judge is going to give you a definition of what a reasonable doubt is. I often look at it as a situation where, in a matter of importance to me, in making a decision about something that's important to me, I would have a serious hesitation or pause. If there was something about that that would give me pause, perhaps that's sufficient to be a reasonable doubt. And in evaluating the state's case, you're not only going to evaluate what the claims are against my client, and what the state says my client did or didn't do, but I would also ask, and let me know if any of you have a problem with this, can you also at the same time be evaluating the quality of the state's case, the quality of the investigation that was done? Is there anybody that would have a problem considering that part of it? Hey, you're asking me, prosecutors, state of Arizona, to hang the yoke of a criminal conviction around this man. Did you do a thorough enough investigation? Is there anybody here that have a problem considering that as well? I see no response. Thank you, ladies and gentlemen.
Thank you. All right, folks. Well, we're going to take another break again. If you are chosen to serve on the jury, there's going to be lots of breaks because a lot of things are going on in the background. And so I need to discuss with the attorneys the panel we have before us, and I think we'll be making a decision on who's going to get chosen for the jury. But to do that, we need to do that outside of your presence. So we will take not a recess for us, but for you. So again, if you want to go out, stretch, get a drink of water, all that stuff, I don't think it's going to take terribly long. But there should be enough time to use the restroom, get a drink of water, go out, make a phone call if you need to. Saying that, though, it is important that you don't discuss the case with each other or with anyone else at this point, okay? If you are picked for the jury, I'm going to give you a really strict instruction called the admonition. It's important that you do not talk about the case to anyone. Okay, do you understand all that? Okay, all right, let's let our jury be excused.
Take our numbers. Oh, yes, thank you. Oh, well, thank you, sweetie.
Take all your belongings.
The record will reflect the presence of the parties and the absence of the jury. All right. Mr. Alcorn, do you want to put any positions you have on the record?
I do, Judge.
Go ahead.
If I may, Mr. Buckets. So I know the court was inclined to strike number 2 and 4. I addressed those just because those are in the first 9 jurors. If we need to, we can address later jurors if necessary. With respect to number 2 and 4, I know it's the court's inclination. I know that Mr. DeBrigida agrees. Under the rule, challenges for cause have to be established by a preponderance of the evidence. I'm not asking necessarily Mr. DeBrigida to make any argument. My argument is, for the court's purposes, I don't believe that there is evidence based on the potential jurors' answers to the court's questions, as well as to my questions and Mr. DeBrigida's questions, such that they can be struck by a preponderance of the evidence, or that my argument is that there is no preponderance of the evidence that the juror cannot render a fair and impartial verdict, which is the specific standard. And so, although I don't think Mr. DeBrigida specifically made the challenge, that's my argument, and I'm asking that they not be struck for cause.
Mr. DeBrigida.
I did make the challenge, and I'm still asking for that challenge, despite the sort of groupthink attempt at rehabilitation by the state. All 3, and I'm speaking of potential jurors, 4 and 2 and 17, they were all pretty adamant in their initial statements that they would clearly give law enforcement officers more weight than they would to someone else because of their respect for law enforcement. I don't think any conversation that Mr. Alcorn had with them after the fact does anything to change that. They perhaps equivocated a bit on some of it and said, well, if this is that and this is that, it's different. Well, it's not different. What their initial statements were not changed in any way. They didn't retract those statements or expressions. They clearly indicated that they would give law enforcement officers testimony greater weight than they should have been struck originally.
Okay. Well, I think I have to agree with the defense. I know that both of them, again, when they were being questioned by Mr. Alcorn, used the term not necessarily. And to me, that by preponderance of the evidence makes me believe that they could not fully be fair and impartial to the defense, that they would lean towards law enforcement. In addition, number 4 is one that just doesn't want to be here. That's not really necessarily cause. I'm going to use that term like they did, but I am going to strike 2 and 4 for cause. All right. So now we have it's really 1 through 12 on here with those 8 sent home for hardship, 2 and 4 have been struck for cause, so 1 through 12 on our list. Mr. Alcorn, do you have any argument with respect to those individuals that we haven't talked about already?
I do, Judge. I'll start with number 12 first.
Okay.
I want to go back to number 11, but I'll start with number 12 first. Number 12 was a juror who indicated that... No, I'm sorry. I'll start with number 11. Number 11 was a juror, I believe, and perhaps the court can correct me if I'm wrong. I believe juror number 11 indicated he did not want to be here. I am concerned over, and I would argue as a challenge for cause, the fact that he has been on a jury in Texas that decides punishment. I raise as an issue that he may potentially consider punishment, even though instructed not to, if selected for a jury, and I would ask to strike number 11 for cause.
Mr. DeBrigida?
I frankly don't have a position one way or another.
I kind of share a concern for number 11. I know he was very kind of, I don't want to use the word proud, but made sure to emphasize that they had given him the maximum penalty. And again, I know it's different in Texas, but my concern, I think I agree with the state that he might lean towards thinking about what a penalty could be. And so because there's no big objection from the defense, I'm going to strike number 11 for cause. So we're now down to through number 13.
14, Judge. You struck number 13.
Oh, yeah, you're right. All right, as to that panel, Mr. Elkhorn, do you have any additional arguments?
I don't, Judge. I've reconsidered number 12.
Okay. Mr. DeBrigida, as to 1 through 14, less the ones we've already been stricken for hardship or cause, do you have a position on any of those?
No further requests to strike for either of those reasons.
Okay. So then it looks like our panel is going to be 1, 3, 5, 6, 7, 9, 10, 12, and 14, correct?
That's my number.
Okay.
Agreed.
So 16, everyone after 16 is excused because we have enough individuals. All right. All right. So are we going to have the folks come in and sit in the back and then call them up? Or we have them in the panel and just let everyone go, kind of thing?
In the past, the way that Judge Wright has done it is everyone comes in the back.
Okay,
I believe either yourself or the clerk calls in the witnesses and they come up front.
okay,
They'll sit in these chairs temporarily. We excuse the remaining jurors, and then whatever business we have left for the morning, I don't know if you plan on reading instructions or whatever.
I don't think we're
And
going
We
to,
can swear them and give them the admonition, excuse them however you want to do it.
And then they're renumbered again, 1 through 9.
Right.
okay. All right, well, let's bring them back in and have them sit in the back.
You want them to sit in the back, Judge?
Yeah, sit in the
So if
back.
you could just find any seat. Find any seat.
There's no problem. Yeah, I heard that's a closing first, but I found that out. I was over my opening. I was like, well, I'll do that next time.
All right, we are back on the record in CR 2023-525, State of Arizona versus Russell Ostrom. The record will reflect the presence of the parties, the defense, and the panel. Ladies and gentlemen, we did have a discussion about who we're going to call as jurors in this case. We only need 9 folks today. Obviously, there is a lot more than 9. And so I'm going to call up the numbers of those that have been selected, keeping in mind that we do consider hardship as well as strikes for cause. So will the following please come up and have a seat in the jury box? Number 1. Official sheet go. Number 3. Number 5. Number 6. Number 7. Number 9. Number 10. Number 12. And number 14. 14. For those of you who are not selected as jurors, thank you very much for your participation here today and for your willingness to serve on the jury. You are now excused. So thank you, everyone in the back. Really appreciate you being here. Have a great day.
Yeah, I know, sit over here so I don't kick it.
So members of the jury, if you will please stand and be sworn.
Please raise your right hand. Do you swear or affirm that you will give careful attention to the proceedings, follow the court's instructions, including the admonition, and render a verdict in accordance with the law and evidence presented to you, so help you God?
I do.
All right, please have a seat. The clerk will now read the charges.
In Gila County Case CR 2023-00525, a direct indictment was filed. The grand jurors of Gila County, in the name of the state of Arizona and by its authority, accused Russell Allen Ostrom, charging that in Gila County, Arizona, Russell Allen Ostrom committed felonies to it, the following. Count 1, theft of means of transportation. On or between November 15th and November 28th, 2023, Russell Allen Ostrom, without lawful authority, knowingly controlled David Burdick's Mazda B2200 with the intent to permanently deprive him of that vehicle. Count 2, theft of means of transportation. On or about November 15th, 2023, Russell Allen Ostrom, without lawful authority, knowingly converted David Burdick's Mazda B2200, entrusted to or placed in the defendant's possession for a limited authorized term or use, signed by 141st grand jury, to which charges defendant has entered a plea of not guilty.
Thank you, Madam Clerk. Okay, so we're coming up on the lunch hour. When we come back, I'm going to be giving you your preliminary jury instructions. However, I'm going to give you the admonition instruction now, just because it might affect your conduct over the lunch hour. So it's kind of long. I'm going to read it. When we come back from lunch, you're going to have it in physical copy, but just so that when we take our break, you'll have that admonition. So, first, do wear your juror badge at all times in and around the courthouse so everyone will know that you are on a jury. Each of you has gained knowledge and information from experiences you have had prior to this trial. Once the trial has begun, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit locations where the events of the case took place. Do not consult any source such as a newspaper, dictionary, a reference manual, television, radio, internet, or any other electronic media for information. If you have a question or need additional information, submit your request in writing and I will discuss it with the attorneys. Do not talk to anyone about the case, about anyone who has anything to do with it, and do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email. This is kind of outdated. It says email, Facebook, MySpace, Twitter, instant messaging, BlackBerry messaging, iPhones, iTouches, Google, or Yahoo. You can imagine that that would also include Snapchat, Instagram, TikTok, any of those other things that the kids are using now. All right? Any internet search engine, any form of electronic communication for any purpose whatsoever as it relates in any way to this case. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case or your courtroom experience with anyone until the trial has ended and you have been discharged as jurors. Until then, you may tell people that you are on a jury and you may tell them the estimated schedule for the trial, but do not tell them anything else except to say you cannot talk about the trial until it is over. That includes your spouse or partner. You can let them know I've been chosen for the jury. It should be done by Friday, and that's about it. Okay? One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply to this case is law that I give you in the final instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, please turn them off and do not turn them on while in the courtroom. You may use them only during breaks so long as you do not use them to communicate about any matter having to do with the case. You are not permitted to take notes with laptops, phones, tape recorders, or any other electronic device. You are only permitted to take notes on the notepads provided to you by the court. Devices that can take pictures are prohibited and may not be used for any purpose. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her and walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, report it to me or any member of my staff as soon as you can. To avoid even the appearance of improper conduct, do not talk to any of the parties, lawyers, or witnesses, media representatives about anything until the case is over, even if your conversation with them has nothing to do with the case. For example, you might pass an attorney in the hall and ask what a good restaurant is downtown. Someone from a distance may think you are talking about the case, so again, please avoid even the appearance of improper conduct. The lawyers and parties have been given the same instruction about not speaking with you jurors, so don't think that they are being unfriendly to you. When you go home tonight and family and friends ask you what the case is about, remember you cannot speak with them about the case. All you can tell them is that you are on a jury, the estimated schedule for trial, and that you cannot talk about the case until it is over. In a civil case, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case such as this, however, the jurors are not permitted to discuss the evidence until all the evidence has been presented and the jurors have retired to deliberate on the verdict. You may not discuss the evidence amongst yourselves until you retire to deliberate on your verdict. Therefore, during breaks and recesses, whether you are assembled in the jury room or not, you shall not discuss any aspect of the case with each other until the case is submitted for you for your deliberations at the end of trial. Again, If you have a question or need additional information, submit your request in writing and I will discuss it with the attorneys. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to hear or understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you've had an opportunity to discuss the case with each other in the jury room at the end of trial. Please advise me in writing immediately if you believe that any juror has violated any provision of this admonition. Before each recess, I will not repeat the entire admonition I have just given you. I'll probably refer to it by saying, please remember the admonition, or something like that. However, even if I forget to make any reference to it, remember that the admonition still applies at all times during trial. All right, so we're going to break for our lunch recess. The attorneys and I will work on some things we need to work on. If you can come back, be back at about 1:20, and we will start at 1:30. Okay? All right, thank you, folks.
Gila, where do you want them to leave the numbers? Where do you want them to leave the numbers?
We're putting them out there.
Okay.
Drop them off out there?
Yeah, please.
Lacey's at the door. We're gonna take it at, right outside the doors.
Oh, yeah. Yeah. Can you give them a copy, please? All right, we have the preliminaries. Let's kind of go over that, so thank you.
Thank you.
Now, on the draft, it has preliminary 1, preliminary 2. Do we want to take that off? I don't want jurors wondering why we've skipped certain numbers.
Yes, in my experience, Judge Wright usually does.
Okay.
Yeah,
So we'll,
just the headings, not the number.
so preliminary criminal 1 we'll take off, but leave importance of jury service, for example, like that. Okay. So let's take off we'll take off all the preliminaries. Do you want to go over these now, or do you want to break now, have a chance to look at them over lunch, and we'll come back like at 1? What works better for you?
I'm fine reviewing them now.
Reviewing now? Okay,
Yeah, I
perfect.
don't think there's that much to go through.
Okay. So we're going to take off those titles. Okay. So we're good with 1, importance of jury service, duty of jurors, number 2, evidence, number 3, 4, direct and circumstantial evidence, 6, evidence, statement of lawyers and rulings, 7, rulings of the court, 9, bench conferences and recesses, 10, credibility of witnesses, 12, juror note-taking, 13, admonition, which we've already given, 16, question by jurors, 18, constitutional right not to testify, 19 is now statement of the defendant, 20, presumption of innocence, burden of proof, 22, the charged offenses, but we need to split the definition of theft of means, right? We're going to So it's going to say, the crime of theft of means of transportation requires proof that the defendant without lawful authority knowingly controlled another person's means of transportation with the intent to permanently deprive the other person of the means of transportation, period. And then do we want it to say, the crime of theft of means of transportation requires proof? I mean, do you want the same heading on there?
I think that works.
Okay.
Wait, I'm sorry, Jen.
So we have it says, the crime of theft of means of transportation requires proof that the defendant without lawful authority, and then it'd be knowingly controlled another person's means of transportation with the intent to permanently deprive the person of the means of transportation, period. Then in the next paragraph, the crime of theft of means of transportation requires proof that the defendant without lawful authority converted for an unauthorized term or use another person's means of transportation that was entrusted to or placed in the defendant's possession for a limited authorized term of use.
Yes, Judge, I did agree with separating them. That's my suggestion. I just showed my colleagues, if I may.
Yeah.
So I'm not saying it has to be done this way, but to kind of break it down.
Okay.
The theories under count 1 and count 2. And then the large one after the definition separates those concepts.
Okay. Any objection to distinguishing between the two, count 1, count 2 as suggested by Mr. DeBrigida with the parenthetical saying permanently deprived and then converted for an unauthorized term?
No objection.
I think that's a good idea. Okay,
Yeah.
we'll do that, Mr. DeBrigida. Do you need this back?
No.
Okay. If I can scan that, well, I'll let Becky know. I'm sure she's listening. Okay. 3, scheduling during trial, last through Friday, November 14th, 9:30 to 5. Recesses, okay. Order of trial. And that's it. Any changes or additions other than those that we discussed?
No, Your Honor.
Okay. All right. So let's take our lunch recess. I told the jury to be back at 1:20. Let's try to be back around that same time. I don't think there's anything necessary we'll need to discuss this afternoon. Okay, but that'll give us a few minutes in case we do. All right?
Thank you, Your Honor.
Thank you.
You don't.